The following presentation deals with sales and various provisions under the Uniform Commercial Code. As with most of the chapters, this chapter does a reasonably good job of covering some of the fundamental aspects of sales, and there are just a few subjects that I will spend a few minutes addressing just to heighten your awareness and be sure that you're paying attention to these topics as you read through the chapter. Be sure and note that the Uniform Commercial Code deals only with, at least Article 2 of the Uniform Commercial Code deals only with sales of goods. So if you've got a sales contract that deals with real estate or services, it would not fall under Article 2 of the Uniform Commercial Code. Goods are both movable and tangible, and there's some material in the chapter elaborating on the definition of what constitutes goods under the UCC. Realize that in every contract under the Uniform Commercial Code, the law imposes an implied covenant of good faith. It's just a term that's implied into all contracts under Article 2, essentially just saying that both parties are promising to act in good faith with respect to the terms and conditions of that contract. Note the definition of merchant. It is a three-part definition, and that generally to be considered a merchant under the UCC, the retailer, notice it wouldn't be just any and every retailer, the seller to be a merchant must be one that regularly deals in goods of the kind involved in the transaction. That's number one under this three-part definition. So just because you happen to be a seller of goods doesn't necessarily make you a merchant with respect to the provisions of Article 2 under the Uniform Commercial Code. You've got to be a merchant, a seller who regularly deals in goods of the kind involved in the transaction. Note that under the Uniform Commercial Code, unlike the general contract law provisions that we looked at in a previous chapter, under the UCC, a modification agreement needs no new consideration. And again, that is unlike the general rules of contract law. So there is no mirror image rule as there was under general contract law. The statute of frauds is something that sometimes people get confused on just a little bit. Notice again, it's a contract for the sale of goods, so it's got to be goods in question. So the contract has to be for a sale of goods. If it's for $500 or more, then the contract must be in writing and signed by the party that you're trying to enforce the contract against. So a contract for the sale of goods of $500 or more must be in writing and signed by the individual that you're seeking to hold accountable under that contract. The parole evidence rule is worth taking a look at. It essentially says that a written contract may not be contradicted by oral testimony. However, oral statements can be used to explain or define the terms of the contract. The sales warranties you should pay attention to, the express warranty and the implied warranty of merchantability and the implied warranty of fitness for a particular purpose. The express warranty, notice how an express warranty can be created. It can either be by some affirmation of fact or a promise made by the seller. It can be made by a description, if there's some sort of a description of the product that is associated with the sale. An express warranty can also be created if you've got a sample of that item sitting out on the sales floor and you look at that sample and it should represent or conform to the finished product. They can't put a sample out on the table for you to look at and then sell you something that is a cheaper version of that and doesn't appear to be conforming to that sample that was shown to you. The implied warranty of merchantability, notice that it is made only by a merchant, and essentially that warranty says that any goods that are being sold must be of merchantable quality. In other words, the goods that are being sold must live up to the industry standards and do whatever it is that product is expected to do. And if it doesn't do it, perform whatever task it is that it's designed to perform. If it breaks, if it does not measure up to industry standards, then they have breached that implied warranty of merchantability. Third on the list, I've got 3 express and implied warranties that are addressed on a handout. The implied warranty of fitness for a particular purpose. Notice the requirements for that particular warranty to be created. So if you were to go into a store looking for a pair of hiking boots, and you explain to the seller what you want to use these boots for, that they're going to be exposed to extreme temperatures, to lots of moisture, maybe lots of walking through mountain streams, and you explain to them exactly what you want those boots for, and the seller, given that information, they tell you which particular pair of boots would best serve your purpose, then this warranty of fitness for a particular purpose has arguably been created, with the occurrence of those facts. One last item worth noting is that if a merchant or if anybody wants to disclaim any of these warranties, those disclaimers must be conspicuous. You can't put a disclaimer in fine print on the back of the last page in a document, in an agreement, and essentially be hiding it from the purchaser. Those disclaimers must be readily visible. They must be conspicuous.